Actress Blake Lively and her actor husband Ryan Reynolds want to keep their messages with seemingly their A-list friends out of the hands of the public, and they're demanding better protections for everyone involved in this case, including witnesses. We've got details from today's hearing and the legal battle between Lively and her co-star Justin Baldoni. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Today, Blake Lively and Justin Baldoni's legal teams met in court to discuss a proposed protective order marking the latest chapter in their explosive legal feud. And the hearing comes after months of back and forth accusations, leaked evidence, a public relations war that has certainly captivated Hollywood, and I would say a lot of us here on social media and online and everywhere. Now, really quick refresher about what we're talking about here. So we have Justin Baldoni and Blake Lively. They starred in It Ends With Us, a film based on a book of the same name. And after filming had wrapped and the premiere had happened, Lively filed a complaint with the California Civil Rights Department, saying that Baldoni and others within his company, Wayfarer Studios, made her uncomfortable on set, that she was harassed, and that Baldoni even sexually harassed her. And she alleges that she tried to voice her concerns, but then they turned around and retaliated against her, and then used a PR and digital team to trash her in the press and on social media. And the whole thing was written up for a piece in the New York Times, who Baldoni then sued, saying that they had trusted Lively's side of the story as fact and had barely reached out to him or his team for comment, and even didn't do the proper due diligence and didn't provide context and the full story. This again, all according to him. And then he turned around on Lively, saying that she was the one who used the press and the media to make herself look better. And all of this is morphed into a consolidated federal civil case involving Lively, Reynolds, Baldoni, Wayfarer, and several others who are allegedly part of this so-called smear campaign. So in today's dramatic courtroom showdown, and there's no cameras there, so we're doing our best to recap about what happened, lawyers squared off about whether or not private text messages from the A-list couple, Lively and Reynolds, should be shielded from public view. This is all amid fears that they could be leaked to the tabloids. And during the hearing, the couple's attorney, Meryl Gavrnsky, argued passionately for an extra layer of security to keep sensitive information under wraps. And this is all connected to a proposal for a protective order that Lively's team had filed back on February 20th. And this is the reason the parties met in court today. Now, protective orders, generally speaking, they do a bunch of things, but generally they govern the disclosure of certain information in a case. And so today in court, as well as in the proposal for the protective order, Lively's team was requesting a designation called Attorney's Eyes Only for certain materials, and this includes private text messages with other high-profile individuals, details about the couple's mental health, security measures they've taken during this ongoing feud. And Lively's attorneys are saying, look, we don't want anyone other than attorneys to have access to this information, hence the Attorney's Eyes Only designation, which I'm going to explain a little bit more in a bit. But it basically means that anything that falls under that designation can't be viewed by anyone other than the attorneys themselves. So essentially and potentially, not even Justin Baldoni or Blake Lively would be able to see anything under that designation. Now, Gavrnsky, in making her argument, said to Judge Lyman, quote, "There is a significant chance of irreparable harm if marginal conversations with high-profile individuals with no relevance to the case were to fall into the wrong hands." Now, the protection of text messages, according to Lively's camp, is especially crucial because among the significant key players in this case are people as high-profile as megastar Taylor Swift, who was referenced and alluded to in Justin Baldoni's lawsuit. By the way, not to take away from this in any way, but I actually wanted to tell you all real quick about something else, something kind of important, affects a lot of people. We don't talk about it a lot. Dandruff. I know, you're like, what? What are you talking about? No, it's a real problem. And look, most people assume it's from a dry scalp, but it's actually caused by an overgrowth of fungus called malassezia. And that fungus, it feeds on the oils inside most shampoos, even some of the ones from dermatologists. But That is where our amazing sponsor, Dermazine, comes in. Take a look at this. So Dermazine's clinically tested overnight serum has a 92% success rate and nearly 3,000 positive testimonies. So while you sleep, it disrupts the biofilm around the fungus, which most dandruff shampoos never touch, so you can target flakes at the source. And right now you can get their scalp relief system for an extra 10% off plus free shipping, and that includes the overnight serum, dermatologist recommended shampoo, a scalp scrubber to clear buildup, boost circulation. So experience flake-free confidence every day. Go to dermazine.com/sidebar for an extra 10% off and free shipping, or tap the link below to get yours today. Now, Gavrnsky also warned that without this extra layer of security, the private details about Blake Lively's life could end up literally everywhere. And she took a jab at some of the co-defendants in this case as well. She told the judge, quote, "The parties in this case on both sides include people whose entire living is made off providing information to the press and content creators. There are 100 million reasons for the parties to leak information because the PR value is greater than complying with the court orders. In other words, there's a bigger advantage to winning in the court of public opinion than maybe even winning in the court of law." That seems to be a fair interpretation of that. So the people that she's referencing here are likely the other co-defendants named in the lawsuit, namely Baldoni's crisis manager, Melissa Nathan, his former publicist, Jennifer Abel, individuals who were supposedly tasked with providing information to the press and online, suggesting that there is a temptation to expose things to make a buck. And so it's pretty indicative that she was expressing some distrust here to Judge Lyman. Again, these are the parties that Blake Lively accuses of being instrumental in this retaliation smear campaign against her. Now, Gavrnsky also emphasized that this case involves what could basically be considered trade secrets. There are marketing plans, there are business strategies, there are client lists from public relations agencies, which could give competitors in the PR industry an unfair advantage if that information is disclosed. And she even expressed concerns about the potential leak of, quote, "specific security measures Miss Lively and Mr. Reynolds have taken to protect themselves and their families from this retaliatory campaign," because we know that this story has certainly circulated in the past few months. People have very strong opinions and passions when it comes to Blake Lively and Ryan Reynolds and Justin Baldoni. Baldoni had apparently subpoenaed a security firm that works with the couple, and Gavrnsky argued there was no reason why their security arrangements should be made public for everybody to see. And she also raised the alarm about the potential disclosure of Lively's medical information, including, quote, "profound mental health issues," as well as details about her children, the locations of private residences, and, quote, "personal and intimate conversations with third parties." And Gavrnsky argued that while these conversations might have, quote, "marginal relevance to the case, their, quote, PR will be high if leaked." And she cited Baldoni's alleged connections to individuals who, quote, "will do anything and hate Miss Lively," claiming he was operating on an unlimited budget and had, quote, "committed $100 million to ruin the lives of Miss Lively and her family." This seems to be in reference to another one of the defendants in this case, Steve Sarowitz, who allegedly pledged at one point that he would spend $100 million to ruin the lives of Miss Lively and her family. Now, Gavrnsky also accused Baldoni's team of even bragging about leaking information, quote, "without fingerprints and in an untraceable way," further heightening the risk of irreparable harm. She argued that even contempt proceedings for violating a protective order wouldn't, quote, "unring the bell" if sensitive information were made public. Now, Justin Baldoni's legal team, they weren't having this. His attorney, Brian Friedman, who, as we know, has been quite outspoken about this case, fired back, calling the proposal unnecessary and even offensive, saying it's offensive that anyone would suggest we would disregard a protective order. This is a case where no one has any intention of beating up or harming Miss Lively in any way. And Friedman went on to say that he believed the court's model protective order, which is the standard order that the federal court has, basically a template, that's protective enough. And as far as the attorney's eyes only stipulation or designation goes, Friedman argued that his team shouldn't be burdened with having to work around that, saying we shouldn't be put into a position where we're the ones that have to run to court every single time just given attorney's eyes only protection. My client has a right to defend himself. And he also argued that Lively and Reynolds' request would unfairly treat celebrities and powerful industry figures differently from everyone else involved in the case, saying it feels like what the other side is asking for is because there is a celebrity, because there are powerful people in the industry, somehow they get treated differently. Somehow there's a different law that applies to them that otherwise wouldn't apply to normal everyday people. Now, Judge Lyman did appear skeptical of some of Lively's requests, noting that they seemed overly broad. He also acknowledged that inherent challenges of litigating a high-profile case in the public eye, that those exist, saying a lot of what you're talking about is inherent in the nature of the case. If you sue a high-profile person in this industry, it's going to get picked up by the press. The stuff that's highly relevant is going to end up being disclosed. So the hearing wrapped up. Judge Lyman didn't issue an immediate ruling, not clear when he's going to do that, but I will tell you what is clear. In the world of Hollywood, where fame and privacy often collide, even text messages can become the center of a legal firestorm. I mean, after all, we all remember how this case started in Blake Lively's civil rights complaint, all of those text messages that were published. Now, in a statement following the hearing, a spokesperson for Blake Lively told the outlet Deadline, quote, "All of the parties agree that there is sensitive information in this case that should be shielded from public disclosure. The Wayfarer party's proposed order would do that. The dispute is about whether a narrow category of already non-public information that should be accessible only to attorneys rather than the parties. That type of provision is standard in civil cases, including in litigation in which Brian Friedman appeared as counsel. This additional protection would ensure that the defendants who have committed to spending $100 million to destroying Miss Lively and her family do not have access to information that only attorneys need to see." So to help you understand a little bit better about how we got here, I want to explain this whole protective order more in depth. And we first heard that Blake Lively's team would be proposing an order back on February 2nd, when her lawyers wrote a letter to Judge Lyman requesting a gag order be placed on Baldoni's attorneys, accusing them of essentially trying their case in the media and releasing information that could potentially prejudice a future jury should this case go to trial. And you'll remember that Baldoni's team, led by Brian Friedman, made some very interesting moves to disclose Baldoni's version of events to the public, such as releasing text messages, creating a website, posting something called a timeline of major events in the case, making an appearance on Megyn Kelly's podcast. And we're going to get more into that a little bit later. But essentially, Lively's team took issue with Friedman's moves to present evidence outside of court in the public eye. So they sent this letter to the judge, and right towards the very end, they say, the Lively Reynolds parties intend to seek an appropriate protective order to govern further proceedings in this case. But given the imminent harm caused by Mr. Friedman's misleading and selective statements and leaks, we respectfully request that this court schedule a hearing as soon as possible to address the appropriate conduct of counsel moving forward in these two related matters. Now, of course, the two sides did meet in court for the first time a day later on February 3rd. Baldoni and Lively, they weren't present. There were no cameras allowed in the courtroom, but our reporter inside was able to get us some details. And the courtroom drama took another dramatic turn when Judge Louis Lyman issued a stern warning to both sides: exercise restraint when talking about this case publicly, or risk moving this trial date up, which is currently set for March 9th of 2026, almost exactly a year away. But if the parties disrespect that, if the parties violate this, he may be within his rights to move this trial up much, much sooner. And Judge Lyman didn't really mince words when he addressed the lawyers in that hearing, saying, "You've got a lot in front of the court that gives, I think, the public plenty to feast upon," referencing the barrage of public statements, leaks, accusations that have really turned this case into a tabloid sensation, and what essentially got us to the proposal for a protective order. So in that February 3rd hearing, Lively's attorney, Michael Gottlieb, painted a grim picture of the fallout from the media battle, describing it as a, quote, arms race with no guardrails. And he compared the legal dynamic between the two teams to, quote, two 4-year-olds in a playground, accusing Baldoni's attorney, Friedman, of fueling a, quote, harassing and retaliatory media campaign against Lively. He went on to say that Lively is apparently devastated by the ongoing feud, which has, of course, dragged her personal and professional life into the spotlight, although, to be clear, she was the one who started this legal fight. But then again, if you take her allegations as true, can you blame her? But again, it hasn't been proven yet. And while the request for the gag order was presented to the judge, he ultimately declined to impose one, at least for now. Now, Friedman, meanwhile, pushed back hard, accusing Lively's team of trying to control the narrative, argued that Baldoni has suffered significant financial and reputational damage from the media coverage, including the now infamous New York Times article, "We Can Bury Anyone Inside a Hollywood Smear Machine." Remember, the Times published this back in December after Lively filed her initial California civil rights complaint. And so I want to look back at how this all fits into the protective order and how we got to today. So Judge Lyman at that hearing asked both sides to submit any proposals for a protective order by March 11th. And now, just as an aside to do this, in the Southern District of New York, which is part of the federal court system, there is something known as a model protective order. As I mentioned, it's basically a template outlining the stipulations required to prevent the public from learning about any sensitive or private case information and to protect the exchange of documents between legal teams. And parties will often submit revisions to the model protective order, propose a new one, because everybody's circumstances are different, which, by the way, is what Lively's team apparently did here. But these changes were seemingly not accepted by Baldoni's team. Specifically, they disapproved of the addition of certain legal language that would alter who would be able to access or view certain documents in the case. And Baldoni's team basically said that Lively is trying to shield things from public view and that she shouldn't be allowed to do that because she herself has gone public with her allegations and spoke with the media, particularly the New York Times, regarding her claims of sexual harassment. Now, essentially, in Lively's proposed order, there is a bunch of added language surrounding what is known as attorney's eyes only. So that's basically a designation for information that can only be viewed by the attorneys in the case, but not the parties themselves. Again, like I said, meaning not Lively or Baldoni. And Lively's proposed order reads, "Any person subject to this protective order who receives from any other person subject to this protective order any discovery material that is designated as confidential or attorney's eyes only shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. The designation attorney's eyes only shall only be utilized for confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, or privacy injury to the producing party." Now, to break this down, let's say Lively's team designates something as attorney's eyes only. That would mean that Baldoni's attorneys can see it, but Baldoni himself can't. And more importantly, neither can the co-defendants on either side of the case, which include PR professionals. And in theory, this would prevent things such as texts or emails or financial records or personal information from being leaked outside of the courtroom to the media. But Baldoni's team took issue with this, criticizing the language for being restrictive, accusing Lively of wanting to prevent the public from accessing relevant materials and evidence to the case. And their response letter to Judge Lyman reads, "Given how actively the Lively parties have publicized and litigated Miss Lively's claims in the media, we are surprised to now learn how vehemently she wants to prevent the public from accessing material and relevant evidence. The Lively parties provided the New York Times with Miss Lively's otherwise confidential administrative complaint filed with the California Civil Rights Department and, quote, thousands of pages of original documents. Miss Lively's counsel and spokesperson routinely attempt to rehabilitate her tarnished image with bold statements to the press, such as characterizing the Wayfarers Party's complaint as another chapter in the abuse playbook, worst of all, in a planned skit on NBC's Saturday Night Live 50th anniversary special, which attracted almost 15 million viewers. Miss Lively's husband, Ryan Reynolds, and we all remember this, stood up and made a joke about her claims for sexual harassment and emotional distress." And as for the attorney's eyes only designation, any protective order permitting attorney's eyes only designation is not warranted. Although the Lively parties contend that the ability to designate information AEO is appropriate because the litigation involves claims of sexual harassment in the workplace, Miss Lively has already publicized the alleged details of the so-called harassment in her amended complaint, spanning 138 pages and almost 500 paragraphs. Furthermore, any legitimate concern the Lively parties have concerning the disclosure of highly sensitive personal information can be addressed under the procedures contained in the court's model protective order. And this follows suit with what both sides argued today in court. Baldoni's team really honing in on how much of this case is already in the press, some of which they say is by Lively's own doing, but Lively's team pushing back for more restrictive measures to protect her. Now, of course, as I said earlier, we don't know exactly what the judge will decide. At the time of this recording, there has been no ruling, but we will keep you updated on this as soon as we know. But I'll tell you what else has been going on in this high-stakes legal drama? To catch you up on all the latest legal proceedings, both sides have suffered what could be considerable losses in the past week. Why? On Tuesday, the defamation suit that Justin Baldoni filed against the New York Times, it faced a setback when the judge essentially granted the Times a stay of discovery, an order that temporarily or indefinitely stopped the process of gathering evidence in the legal case. And why is that a win for the New York Times? Well, because on February 28th, the publication, the newspaper, filed a motion to be dismissed from the $400 million defamation suit. And again, this is the big suit that names not just the Times, but also Blake Lively and other parties. And Baldoni has accused the outlet, just to reiterate, of cherry-picking evidence presented by Lively's team, working in cahoots with her to publish the article just one day after Lively filed her complaint. And in the Times filing to be dismissed from the case, they argue in part the only thing the Times is, in fact, alleged to have done is engage in news gathering and publishing an article and video about the Wayfair-Lively dispute. The Wayfair parties have failed to allege a claim against the Times, and this court should, therefore, dismiss the first amended complaint as alleged against it pursuant to Rule 12b-6. And Rule 12b-6 allows a court to dismiss a case if, after accepting all the facts in the complaint as true, the plaintiff has essentially failed to state a valid claim for which relief can be granted. In simpler terms, this means the plaintiff has to present a plausible legal cause of action. There has to be a legitimate basis for the case to proceed. If the complaint doesn't meet this standard, showing no viable legal claim, there's no case to move forward with. And they additionally filed for the motion to stay discovery, to pause or suspend discovery, which the judge granted as he continues to ponder their motion to be dismissed. And part of this ruling on the stay of discovery reads, and it seems to be consistent with what the New York Times had argued, quote, "The Wayfair parties are unlikely to be unfairly prejudiced by a stay while the court decides the pending motion. The New York Times did not delay filing its motion. It filed the motion within 21 days of being served. The court intends to address the motion to dismiss promptly after it is fully submitted. To the extent that the Wayfair parties are concerned about delay, they have it within their power to accelerate their contemplated further amended complaint or their opposition to the motion to dismiss." And Judge Lyman also emphasized the sensitivity of the materials that may be requested, which could complicate the legal process further. And Lively's team hit a major roadblock, too, just a few days ago, when Judge Lyman partially denied her team's request to access Baldoni's phone records along with those of others that she's suing. So the judge described that request as overly inclusive, putting a damper on her side's efforts to uncover evidence in this case. And Lively's team was attempting to subpoena Baldoni's phone records to uncover evidence that he and his team were truly trying to smear her in a plot aimed at tarnishing her reputation. But Judge Lyman denied part of Lively's request on Friday, ruling that her request seemingly violated privacy rights, particularly since the phone records could reveal sensitive information about contacts, including medical professionals and acquaintances, raising concerns about specific allegations in the case. In Judge Lyman's ruling, he wrote, "This request implicates legitimate privacy interests. Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfair parties spoke to and when. So the call logs, even themselves, could be a problem." And while the judge blocked her request for Baldoni's records, the ruling wasn't a complete loss for Blake Lively, because Judge Lyman is allowing Blake Lively to subpoena the records of other individuals who may be connected to the alleged smear campaign. And that part of his ruling reads, "Lively's complaint already identifies many individuals who allegedly participated in a negative media campaign. Lively may make discovery requests tailored to those individuals. She is permitted to use the tools of discovery to identify the contact information or telephone numbers for those individuals." And he further noted that while it's unclear if there were more people who allegedly participated in this plot, there was no justifications for such broad subpoenas of Baldoni's records. Now, if you're looking at all this and you've gotten to this part of the video, you might be saying either I totally get everything, or you might be saying I have no idea what's going on. So if you're just learning about this for the first time, this legal battle between Blake Lively and Justin Baldoni, it started back in December, but the tensions had been simmering very long before that, because here's just a breakdown of the key events. So December 20th, Lively filed her bombshell complaint with California Civil Rights Department accusing Baldoni of creating a hostile work environment on the set of the movie It Ends With Us. And she alleged, among other things, that Baldoni entered her trailer uninvited while she was breastfeeding, made inappropriate comments about sex, pornography, engaged in, quote, disturbing behavior during filming. And she also accused Baldoni and his PR team of launching a smear campaign against her after she raised her concerns. And then one day later, the New York Times published the article that we mentioned before, an article detailing Lively's allegations. It included text messages and emails. And Baldoni later claimed that the article, as I said, was cherry-picked, that it altered communications. And then on New Year's Eve, Baldoni took action, filing a $250 million lawsuit against the New York Times. And then 2 weeks later, he took even more legal action, filing a $400 million defamation lawsuit against Blake Lively, and has even accused her of trying to take control over the film and weaponizing false allegations against him. And then, to further his claims that Lively had allegedly lied about being uncomfortable on set, Baldoni's team released video footage to outlets including TMZ showcasing a behind-the-scenes moment on the set of the movie, and in the clip, Lively is filming a scene with Baldoni in which the two are slow dancing for a montage. And in her lawsuit, Lively alleged that it was during this scene, which she said had no dialogue, that Baldoni leaned forward, slowly dragged his lips from her ear and down her neck as he said it smells so good. And when Lively later objected to this behavior, she claims that Mr. Baldoni's response was, "I'm not even attracted to you." However, in audio that was captured during this scene, the two can be heard talking, joking out of character while they dance. Lively can be heard telling him, "I'm probably getting spray tan on you," and laughing, and Baldoni replies, "It smells good." Now, her team has come forward and says, actually, this video proves her point, proves how uncomfortable she was. So he said, she said. But then we have a voice note. So this voice note, apparently sent by Justin Baldoni to Blake Lively, allegedly regarding her attempt to rewrite the movie's infamous rooftop scene, that was leaked, presumably, by Baldoni's side. And although it wasn't confirmed that Baldoni's team leaked this, it's interesting because that leaked audio clip seemingly or arguably portrays Baldoni seemingly apologizing to Blake Lively for his response to her script tweaks. And in terms of what Baldoni definitely leaked, or seemed to definitely leak, we know just 2 days before the first hearing, Baldoni seemingly launched, and his team seemingly launched, a website titled Lawsuit Info, where he posted his amended complaint and his version of a timeline of events. And the site included screenshots of alleged conversations with Blake Lively, Ryan Reynolds, never saw these before. And one day before her proposed protective order, Lively filed an amended complaint which included new allegations that Baldoni's behavior made at least 2 additional female cast members uncomfortable. She claimed the women confided in her, and she documented their complaints in writing. And in recent weeks, the battle's only intensified, with Lively's team adding Nick Shapiro, a former CIA official, to her legal team to advise on communications. So at its core, this case is about more than just Lively and Baldoni. It is a high-stakes clash over power, reputation, accountability. And with the trial still a year away, both sides are digging in for a long fight. And today's hearing on the protective order is just one more skirmish in a war that honestly shows no signs of ending anytime soon. That's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.